Hello, everybody. Today, we're hosting another event of the BUL International Law Group. This time, our event focuses on digital evidence and international courts. The event is being chaired by Dr. Abrusci from Brunel University London, and she is going to take the lead now in order to introduce to you also the speakers of this event. For my part, to let you know that the event is being also recorded, and that in essence, the recording will appear in the Brunel Law School YouTube channel. So subscribe if you want to get noticed firsthand. Also, to let you know that you have the opportunity to ask questions to our panelists towards the end of the session. So think already for many questions you would like to ask, and you can pose them in the Q&A section of this Zoom room. With this, I give the podium to Dr. Abrusci, the chair of this panel, who will introduce to us the speakers and will wage also the discussion afterwards. Dr. Abrusci, the podium is yours.
Thank you very much, Dr. Solomon, and welcome to everyone to this webinar. I'm really honored to chair today's discussion that I'm sure is going to be a very interesting and thought-provoking one, especially because we have a stellar lineup of speakers. And the topic of today is digital evidence and international courts. This probably is one of the hot topics in international law at the moment. Indeed, the use of digital technologies in the legal space are bringing lots of opportunities and challenges, and we are now called to discuss them. And as conflicts and human rights violations are continuing worldwide, technology could be a real ally to help us document the atrocities and crimes carried out everywhere in the world, and especially for bringing justice to victims and ensure accountability for perpetrators. However, and indeed, digital evidence are used and are becoming more and more used by international courts, but there are a lot of questions that are still unanswered. And those questions are several, ranging from what are digital evidence and what are the advantages and the limits that they have in international adjudication, and how should we use them, and is international law ready to accommodate their use? How is the ICC and other regional and international courts facing the use of this evidence? And what can civil society do in this sense? And how can we store them? And what are the role and the challenges linked to digital database, something that we may have heard about? And lastly, but not least, how can we ensure that they are reliable and authentic in a world that is dominated by fake news and disinformation? And to some of these questions, and to even more questions, our amazing speakers will try to give an answer today. And I'm really pleased to have with us today Professor Alexa Koenig, who's the Executive Director of the UC Berkeley Human Rights Center and a lecturer at UC Berkeley School of Law. Alexa is the co-founder and former director of the Investigation Lab, which has pioneered the use of social media and other online information to strengthen legal investigation and investigative reporting. And she has trained hundreds of war crimes investigators and human rights researchers around the world. Alexa directed the development of the Berkeley Protocol, which was released in December 2020 in partnership with the UN Human Rights Office to set exactly international standards for online open source investigation. Her most recent books include Hiding in Plain Sight and Digital Witness, published by Oxford University Press in 2020. Thank you very much, Alexa, to be here. Then we have Professor Yvonne McDermott Rees. Yvonne is a professor of law at Swansea University. She was from 2018 to 2021 the principal investigator for an amazing project called the OSR for Rights Project, a multidisciplinary project that examines how open source research has transformed the landscape of human rights fact-finding. Yvonne is a legal advisor at the Global Legal Action Network and an associate academic fellow at the Honorable Society of the Inner Temple. Thank you very much, Yvonne, to be with us. And last but not least, we have Raquel Vazquez Llorente, who's the head of law and policy, technology, threats and opportunities at Witness. Before joining Witness, Raquel was also the permanent representative to the International Criminal Court for FIDEASH, the International Federation for Human Rights. And prior to that, Raquel helped build Eyewitness, an organization that developed award-winning technology to verify and authenticate photo and video. In a role, she led strategic partnership with technologists, litigation networks, and activists that contributed to the documentation and investigation of international crimes in Central America, the Middle East, Africa, and Eastern Europe. Raquel is also part of the inaugural class of the Obama Foundation European Leaders Program. So we are really honored to have all of you today to walk us into the realm of digital evidence in international courts. As Dr. Solomon has said, you are all welcome to write your questions in the QA while you listen to our speaker's presentation. They will present for 10-15 minutes, but we will leave all the Q&A session at the end of the 3 presentations. So without further ado, I give the floor to Professor Koenig. Please, you have the floor.
Thank you so much to Dr. Solomon and Dr. Abrusci for the invitation to speak this afternoon with all of you. And I am so thrilled and honored to be on a panel with Professor McDermott Rees and with Ms. Vazquez Llorente, 2 of the scholars and practitioners whose work I admire so deeply in this space. So I'm just going to speak for about 10 to 15 minutes really quickly to set the stage around digital evidence and its growing importance to some of the international criminal cases that we are seeing emerge in both international court systems and also in national courts around the world. The Human Rights Center, just by way of background, is a multidisciplinary research and investigation center based on the University of California, Berkeley campus. We've been around for close to 30 years at this point. Our foundation is very much in the field of investigations because our founder, Professor Eric Stover, came very much from a boots on the ground perspective in the former Yugoslavia, in Iraq, in Rwanda, investigating the many different international crimes that unfortunately we were seeing break out around the world in the 1990s and into the 2000s. So he brought that sensibility of how can we act as a bridge between the academic world that we are a part of and also the practitioner world that is constantly having to pivot and evolve to address new technologies and new information. So in 2009, we hosted what I believe may have been the first global conference, bringing together people from all different areas of practice to talk about the ways that digital technologies were changing fact-finding in the human rights investigation space. That particular conference was called The Soul of the New Machine, and organizations from around the world were a part of that kind of burgeoning conversation, including Witness and others represented here today. In 2011, we began a massive research project to think about how our information environment was shifting in ways that provided both new opportunities for and new challenges to collecting information that could strengthen international criminal cases. One of the things that many observers were noticing at the 10-year anniversary of the International Criminal Court being in practice was that there were a series of cases that were not proceeding to later periods of investigation, in part because the judges were saying that there wasn't enough corroborating data coming in to strengthen what survivors and their witnesses were claiming had happened in their communities. And that seemed like a perfect moment as we were seeing the spread of the smartphone to communities across the globe, providing new opportunities to capture with visual information, but also to share text about what they were witnessing and observing. Also with the rise of, so we had social media, we had the smartphone, we had a drop in price and increase in accessibility and satellite imagery, all of which could lend new perspectives to both strengthen the narratives that were coming into courts, but also prove new opportunities to get closer to a broader range of understandings of what was taking place. That really then led to our working with the Office of the Prosecutor, but also with practitioners around the world to talk about, do we need to be really thinking collectively and critically and creatively about this new information environment, and how we create some standardization about how we think about and how we talk about the kinds of data we were seeing increasingly becoming relevant to courts. So that began really our 10-year process of really documenting and laying out what are those buckets of information, who's already beginning to work with them, What do we know about the admissibility of this kind of content, the weight that's being attributed to it in different court systems? And we worked very much with a number of NGOs to kind of do a fact-finding and mapping of that information ecosystem. And what we learned was that digital information was coming into courts in somewhat of an ad hoc manner. It depended, of course, on the technological capabilities of those court systems themselves, the extent to and the ways in which people on the ground were collecting information, and also just trying to figure out what the processes were that people were using for verification, authentication of this kind of information. Even back in 2015, 2016, you were seeing things happen like someone would find a social media post that was potentially relevant to a case, and someone would screenshot it, they would convert it to a PDF, they would put some kind of universal date and timestamp on it. And that was sort of the standard for handling this kind of information for court purposes. But increasingly, we were seeing judges wanting other indicia of reliability. So they were understanding that photoshopping could be used to basically distort the information people might find or might put up online. We, of course, saw the rise of algorithms being used to generate people's faces and potentially even full videos, whole cloth. There was a widely publicized kind of outbreak of staging of videos and photographs that were making a lot of people in the international justice community a little bit nervous and trying to think about how we protect due process in such a volatile type of environment. So one of the areas or the subcategories of digital evidence that our team began looking closely at was an area known as digital open source information. So digital in the sense that it was information coming up onto the internet, open source in the sense that it was information that any member of the public could, in theory, access, either through observation, by requesting access, or by purchasing it. So some nominal fee, like paying a subscription fee to a newspaper or to a magazine, something that was in the purview of most people who are able to get online. It's also the kind of information where you don't have to have some kind of special status to get access, like law enforcement status, where you would issue a warrant or subpoena for the information. It also doesn't include information that you would use some kind of illegal activity to get access to, like illegal forms of hacking. So that would be outside the purview of open source information. On that last point, my colleague Lindsay Freeman has been doing some very interesting research on looking at hacked and leaked information and how once it comes into the public purview, it may become this form of digital open source information that can be used for a variety of end purposes. The other thing we really saw a need for was some growing common understanding of the terminology in the space. So digital open source information really comes in part from the intelligence communities of a number of different governments around the world, where the information was being used for decision-making purposes. So a classic example would be during World War II, listening to radio broadcasts in hostile territories, or reading the newspapers of your adversaries to try to pull together information about where troops may be mobilizing and what was taking place on the ground, and then using that for your own tactical decision-making around where you might actually station your troops or how you might pivot next. So you have that piece. You also had a lot of people in the media who were using it, and particularly looking at what's called user-generated content coming up onto Twitter and Facebook and YouTube, LinkedIn, and other platforms. User-generated content being the stuff that platform users themselves were capturing about the ground truths in their own communities and sharing information out to the international community about what they were observing and experiencing. And then you had, so we were hearing though this term OSINT popping up, and I think to this day it's still used as a shorthand for the entire bucket of digital open source information. We would now bracket that into the categories of open source information used for intelligence or decision-making purposes, open source information used as lead information. So for example, getting a sense of who your witnesses could be or where there might be physical evidence of atrocities by watching the videos that people are putting up online, even getting a sense of the crime-based information. And then finally, the third bucket really being what could be called evidence, the information that is introduced in courts to help prove an issue at fact in a case. So starting in 2017, just realizing we needed this common terminology, we needed a foundation for this whole field of practice to grow. Lindsay Freeman and I began interviewing more than 100, and I think it was roughly 150 people around the world. We began co-hosting with a number of organizations globally, different workshops to help resolve contested areas of practice in this burgeoning space. How do we think, for example, about the legal issues that arise when you take on a false identity to say, go on Facebook and start gathering information that could be helpful for court purposes? Is that going to in some way jeopardize your cases, et cetera? All of this was being made possible by the evolution of digital technologies. And that's an evolution we've seen affect fact-finding for legal purposes for centuries, if not millennia. So thinking about the ways that new print technologies in the form of the printing press allowed information to be disseminated, but also become a source of information for courts. The rise of photography and the ways that that spread in the 1800s up into radio and television, the internet, and now mobile devices. All of those technologies have allowed information to spread further across geographic space and more quickly and at a volume unlike anything we have previously seen. And so I think one of the really radical shifts for the international criminal justice proceedings has been, how do we begin to find the signal in all that noise for information that's reliable and can actually be used to support or disprove what survivors have been saying? And just to give a sense of the scale of that, I think the most recent statistics that I've seen, and I've used this for a few years now, so I'm guessing it's now outdated and might be even bigger numbers, but that about 6,000 tweets are currently being generated every second, and about 500 hours of video are being uploaded to YouTube every minute. So the challenge today has really become, how can we use new technologies and smarter methodologies to begin to bring that enormous digital data set down to human scale, where we can actually find what's useful and reliable and bring it into our own fact-finding purposes. The sources that we might be talking about with digital open source information are things like websites, social media I've already mentioned, but even just getting very clever and using a lot of the tools that are available to do smart searching on Google and other search engines. It also incorporates things that we often don't think about as digital open source information and that we've used historically, like government records or other legal records and documents that might be now publicly accessible. There's been a few big milestone cases that have come up over the last decade or so, and I'll kind of close with this. One is the M8 Downing of Mh17 over Ukraine. It was a flight, as many of you probably remember, that took off from the Netherlands. Russia initially denied any role in having downed that passenger jet. And groups like Bellingcat and others did parallel civil society investigations to what was being done by the Dutch forensic investigations team to begin to pull together videos and photographs and other clues from the internet that would help tie this particular atrocity to Russia itself. And I think it really was a moment back in 2014 that began to open people's eyes to the potential utility of this kind of data. We also have a couple of very noteworthy cases in the International Criminal Court, like the Al-Mahdi case and the Al-Hassan case, both of which deal with the destruction of cultural heritage property in Timbuktu, Mali, where you have a geolocation report that was submitted as evidence. Geolocation being a common digital open source investigation tactic of taking videos and photographs that are available about a particular incident and comparing them to satellite imagery to help establish the location where this likely occurred and provide some form of verification. And then finally, the Al-Warfali case in 2017, as many of you may already know, a warrant of arrest was issued for a gentleman by the name of Al-Warfali, who was a leader in the Al-Saika brigade in Libya. He was being accused of the extrajudicial killing of more than 30 people. And that warrant of arrest pulled together a series of videos that have been posted to social media. Those videos were a primary underlying piece of information or evidence that became the basis for that warrant. Today, of course, we are also seeing this kind of evidence and information really come to the fore in the context of Ukraine, which I'm guessing my colleagues will be talking about shortly. We were very pleased to see that the Berkeley Protocol on Digital Open Source Investigations, which we launched in December 2020 with the UN Human Rights Office, is now being used by the Prosecutor General for Ukraine in her collection and her team's collection of digital evidence that might be used eventually to bring cases related to that crime set. Also, the International Criminal Court, we developed the protocol in part by my colleague Lindsay Freeman being based at the court and being able to test portions of the protocol against the court's own investigations and bring the insights from those investigations back to the protocol. While the protocol sets a floor or a foundation for doing this kind of work, I think it's really incumbent on every investigations team to develop their own standard operating procedures where they lay out the tools and the day-to-day workflow of how they're going to use with this information. The protocol should be released later this year in at least 3 additional languages. So Spanish is coming, I understand, next, as well as French and Russian. It has already been translated to Ukrainian, and we will see it in the remaining languages of the United Nations by sometime in 2023. So I think with that, I will conclude and pass it on. Thank you.
Thank you very much for this amazing start of this conversation and to laying the ground on digital evidence. And now I'll pass it to Professor Yvonne McDermott Rees. And I forgot to say before that she's now starting a second incredible research project is so much linked to today's conversation about this called True, and is about the impact of the rise of deep fakes on trust in user-generated evidence of human rights violation. So we move from the criminal law to more the human rights aspect of the discussion. And without further ado, you have the floor. Thank you.
Thank you so much, and thank you also for me for that, for the invitation, for that fantastic introduction. Thanks also to Alexa. That's a brilliant presentation to kick things off. It's just a hard act to follow, but I'll do my best. I actually might start with a shameless plug. So 2 things I'm going to draw quite heavily on in this presentation. Let me just share the screen. One is this special issue of the Journal of International Criminal Justice. That was co-edited by myself and Alexa, our colleague Dara Murray and Emma Irving, and Raquel contributes to 2 articles in this special issue. So a lot of the stuff I'm going to talk about is covered here. But in particular, I'm going to draw on this article, which was just released little less than a month ago now, on mapping the use of open source research in UN human rights investigations. So this is available open access if anyone wants to take a look after this. So in that article, we spoke to UN human rights fact-finding missions, commissions of inquiry, just to get a sense of the extent to which open source information was being used in practice, and also some of the challenges and opportunities that this new type of digital open source information in particular provides. So I guess I'd start with an important point, which is about what we mean when we talk about open source information. So as Alexa mentioned, digital open source information is defined by the Berkeley Protocol as basically information on the internet that anyone can access through observation, purchase or request. But we found an interesting thing when we spoke to investigators, which was that sometimes people would say things to us like, oh, open source information, I could never, you would never see that in court, or I would never rely on that. And then others that we spoke to would say things like, open source information is absolutely crucial to what I do in my day-to-day work. It's it's the first place I start. And we kind of wonder what's happening here. And very quickly it became apparent that those 2 groups of people were talking about really quite different things. So in the first camp, those who thought like open source information, well, it can't really be relied upon, unlikely to see it being used in court. We're typically talking about things like NGO reports, secondary accounts of, perhaps someone has gone and spoken to lots of witnesses and then compiled all of what they've heard into a report, but perhaps the original source of that information is unavailable. And of course, that's logical, right? That kind of information would be less likely to be used in courtroom proceedings. And in the first camp, really what those individuals who saw open source and information and its huge value, we're talking about what we might call primary sources of data. So things like photographs captured online or shared online, videos, or even things like satellite imagery. So very different things. So in this mapping article, we make that distinction between primary and secondary accounts, but we also make the distinction between unique pieces of data and aggregate data. So the unique pieces of data might be a transcript from a court, or a transcript from Parliament, or a photograph or a video, whereas aggregated data might be something that's based on a collection of sources where you can't really get down to the individual piece of information. And so that's an important distinction. I think it's true to say that, Alexa and the team at Berkeley were way ahead of the curve, even starting to think about this in 2009. Even when OSR for Rights started in 2018, I think there was a sense that this is quite a niche and interesting little topic here. And by today, I mean, open source information is really, no one questions its importance in the context of human rights fact-finding. And we're increasingly seeing commissions of inquiry and fact-finding missions hiring individuals who are specialized in these skills. And that's something that's really taken off in the last couple of years, not least because of the Berkeley Protocol and the increased sort of professionalization of practice, I would say, in this space. In terms of some of the advantages, well, it goes without saying that investigations always face some levels of access issues in terms of getting to speak to the right people or being able to really get a full picture of what happened. And so one thing that's really came out in our interviews were people saying, you can just gather so much more information so much quicker than you could ever hope to do in terms of on the ground investigations. And, that in turn can then inform those traditional forms of investigations by giving leads to say, okay, well, we should go and talk to people who witnessed this incident, or trying to follow up to get more information about a particular incident that investigators might wish to look at. Some of the other advantages, so social media can be really useful in providing linkage evidence or evidence of networks between individuals. Often that's the case that people say, oh, no, I have no idea who that is. And then so each other already. One thing that we see a lot in the literature in this space is this idea that it's the great leveler, that where you have investigations that are based on the ground, talking to witnesses, that's heavily mediated, right? You have to have someone who's in the community who links you up with individuals and whose voices get to be heard, can really be dependent on their status in society or on their connections. So in theory, at least, anyone with a mobile phone can pick it up and record and share information online. But in practice, as we've talked about in some of the things we've written, whose voices get heard and who gets to tell their story is itself really heavily mediated. And so not everyone has access to a mobile phone, not everyone has access to mobile internet. There are cost implications, there are resource and safety implications. So we can't really approach it with this assumption that we suddenly get a full picture. I think that's one of the main points I get across, is that this isn't a silver bullet. Of course, it has advantages, but there are also some disadvantages as well. Alexa and Ulick in their contribution to that special issue, Ulick Egan, a PhD student here at Swansea, talked about the investigation of sexual and gender-based violence through open source investigative methods. And I think they've done a really brilliant job in highlighting, again, perhaps some of the assumptions. So one of the assumptions one hears a lot is, oh, well, open source information is brilliant for proving airstrikes or really visible human rights violations, but it's less helpful when you're coming to investigate sexual and gender-based violence. what Alexa and Ulick have proven in their work is that sometimes actually that information is hiding in plain sight. It's just that investigators perhaps approach investigations with this assumption that they're not going to find relevant information, and then of course they don't. So they've made some really brilliant recommendations for investigators in this space in terms of thinking about the composition of investigative teams, how one might set an investigation up to be able to find that kind of information. In terms of other advantages, so one thing I think that was interesting in some of the research that we did was that I think this again was something that shifted over time. So initially, this digital open source information was seen as a really valuable thing to corroborate other accounts, or to, you know, help assess the authenticity or the relevance or reliability of another piece of information that had been gathered. Over time, I think we definitely saw a shift into accepting, as Alexa mentioned, that actually it can be used as a direct evidence of violations. And the Albert Valley case is a good example of this. This is a video taken from social media showing the accused himself being involved in these alleged atrocities. So I think with enough corroboration and with using some of these techniques that investigators use to verify each piece of content, it is possible for open source information to be used as direct evidence of a violation. Then quickly then on some of the disadvantages or some of the challenges. So I think particularly in the context of the pandemic, there was this idea that, well, you know, we certainly won't be able to travel. So open source information, this is, as I said, the silver bullet that can address all of these access issues that we have. And, you know, I think sometimes there's a perception that it's cheaper than conducting on the ground investigations. But actually, when you look at how time consuming and resource intensive the work of finding the most relevant evidence, then preserving it, then verifying it, it's far from super cost effective and yeah, not resource intensive type way of doing investigations. Some of the other things that came up and we talked about this in our mapping article, was the extent to which the existence of open source information in the whole landscape can have an impact on witness perceptions and what they think investigators want to hear about. So some people said, you know, they go to do on the ground investigations, and because a particular incident had gone viral or a video had gone viral, then witnesses kind of said, oh, you must want to talk about that particular incident. And it's like, no, we want to actually ask you about something else. So that was an interesting finding. Elsewhere, we've written about blind spots and the incompleteness of open source information. And again, just to emphasize that we can't see it as a panacea to all of, you know, as with every form of evidence, biases can appear and kind of an impact on the picture that's been told using the evidence. So investigators have to keep their minds open to, be it algorithmic bias or cognitive bias, or even some of the access issues that can arise when it comes to what we're actually seeing when we're conducting online open source investigations. So I'm going to leave it at that. And I'll hand over to Raquel and we can discuss further after in the Q&A. Thank you.
Thanks so much. And yes, now last but not least, Raquel Vazquez Llorente. And thank you very much for those in the audience that are already starting typing your questions in the Q&A. Feel free to do and continue to do so. And after the last presentation, we'll start the Q&A session. Thank you. Raquel, over to you.
Thanks. I should start by lowering everybody's expectations and saying that I'm not an academic, but hopefully I can bring a complementary point of view to Professor Koenig's and McDermott's work. And indeed, a lot of my work with activists and documenters across the globe has been strengthened by the research they both have done. So I come from a practitioner's angle, but if any of you here is doing research, academic or otherwise, and what I say resonates with you, please get in touch. So roughly for the next 12 minutes, I thought I would give some initial thoughts on three main areas. The first one that I want to touch on is why the nature of digital information makes it hard
for international investigations to work with this type of evidence, and what initiatives can help with the authentication of digital content, in particular photo and video. Then I would like to touch on one of the most wicked challenges, in my view, at the intersection of digital evidence gathering and international justice, and that is the preservation of social media content that is being taken down by the platforms. And the final point I want to share with you is, well, when this digital evidence is inserted into court, what happens? So before I start, I would like to flag that this panel is important because, as we are seeing in Ukraine, with more technology being ubiquitous in armed conflicts, online information and generally speaking, digital information are going to play an increasingly important role. And if we look at the history of international justice, Nuremberg was one of the first courtrooms after domestic trials in the US and in the UK that used video as evidence. Obviously, in Nuremberg, it was not digital video, but I wanted to make this brief remark to illustrate that international tribunals, perhaps by necessity, are good sources of innovation. As Professor Koenig and McDermott have mentioned, neither open source information nor digital information is new in the context of investigations for atrocity crimes. But what is new is what I will call the 3 V's, volume, velocity, and volatility. So I just want to add a bit on these 3 areas briefly and connect it to my work as a practitioner. So to start with, on the big volume of evidentiary records. So investigators, as Professor Koenig has mentioned, have moved from having limited or manageable amounts of evidence to trying to find the signal in the noise. For instance, the first trial at the International Criminal Court, the trial against Lubanga, had 1,400 items of documentary evidence over 6 years of trial. And now if we look at Ukraine, only in TikTok, #Ukraine has almost 48 billion with B views. And TikTok is a small size platform compared to like the big ones like Facebook or YouTube that has almost twice the amount of monthly users, over twice the amount of monthly users. The second attribute I mentioned is the velocity. So if we take the metrics that Professor Koenig has mentioned, one person born today will have to live 82 years to watch all the content uploaded in only 1 day on YouTube. And that would mean that this person doesn't do anything else, no sleeping, no eating, no rest, 82 years just to watch the content uploaded on YouTube in 1 day. And the third attribute that I mentioned, and I'm gonna stop here for a couple of minutes because it's part of the focus of my work at the moment, is volatility. So digital information is easy to manipulate, and increasingly so because we are seeing this with the advent of synthetic media or deepfakes. So synthetic media is content that has been generated or modified, often via artificial intelligence, in a way that to the naked eye or ear simulates content that is generated by human activity. So I think it's important, and I want to highlight here a couple of initiatives that can help with proving whether a piece of content has been altered. And we're seeing an evolution in this area from niche tools to prove authenticity that were actually pioneered in the human rights field to efforts that are now more widespread and are driven by companies, governments, platforms, but also by public demand with the rise of mis and disinformation. As Dr. Abrusci has mentioned, I used to work for Eyewitness, which was established by the International Bar Association to provide human rights defenders with a mobile phone app to verify and authenticate photo and video in a way that could be used as evidence in court. And this is an example of a targeted niche tool pioneered in the human rights community. And now I work for Witness. I know the names are confusing because they're very similar, different organizations. So now I work for Witness, where we are exploring what we call provenance and authenticity infrastructure to confront media manipulation. And this is essentially a streamlined way of tracking the origins of images, video, and audio. So this means showing whether they have been manipulated, miscontextualized, or edited, and if so, how, when, and by whom. At Witness, we are part of the Coalition for Content Provenance and Authenticity, which is a bit of a mouthful. So we also call it C2PA by its acronym. And this is a coalition with Adobe, Microsoft, Twitter, and others. And this coalition is developing technical specifications for tracing the provenance and authenticity of digital assets, such as video and images. So for instance, this is an example of more widespread efforts that I mentioned And I can put later links to resources that have been authored by my colleagues San Gregory and Jacobo Castellanos, and I can put them in the chat before the end of the session. So as initiatives like this that look at integrity, provenance, and changes to media at scale continue developing, at Witness, our main focus now is on ensuring that these technical developments do not harm human rights and vulnerable communities, and in fact protect privacy, trust, and enhance freedom of expression, as well as other rights. So this systemic work that we do is grounded in our ongoing support to activists and documenters using video and technology for human rights, and also in our efforts to integrate grassroots and global voices into the advocacy we do to tech platforms. So I wanted to go a bit on the sideline on volatility because it is part of our focus at Witness, but now I want to go back to speak briefly about the volume and velocity at which online digital evidence is being generated. As both Professor Koenig and McDermott have mentioned, international prosecutors have moved from working in environments where it was very difficult to obtain information about the atrocities being taking place in a country. And now we have contexts where internet and smartphones have enabled the capture of photo and video by multiple different actors. So 9 years ago, we didn't think this would be an issue, but Syria was a wake-up call. To give you an idea, the Syrian mechanism that was established in 2016 has, last time I checked, over 2 million records in their evidentiary database and works with around 220 civil society groups. So we can imagine if there is one day a mechanism for Ukraine, the amount of evidence it will have to deal with. So with ever-increasing volume of information comes ever-increasing irrelevant information. So we have moved from a world where there was no information to trying to find the needle in the haystack. And this can truly burden prosecutors and investigators, particularly when dossiers are directed to national prosecutors who need to investigate both incriminating and exculpatory information. And it also, of course, brings other issues in terms of maintaining servers, different file formats. It brings questions about defense rights and data protection. And some of these questions are explored on the series that Professor McDermott mentioned on the volume, special volume. So that initial assumption was that bigger volume will help build more cases because that information is now available. However, to complicate the matter, what's happened in the past few years is that many countries are passing legislation that is forcing tech companies to remove content that is violent or graphic. As a result, across social media platforms, machine learning enabled algorithms are taking down content that violates the platform use guidelines. So 99.5% of the content that YouTube takes down is done so automatically. So virtually all of it, it's a huge amount. So it's around 3.5 million videos between October and December 2021. So in those few months, in that time, around 32% of the content that was taken down by YouTube had not been viewed at all by a human. And why I'm mentioning these statistics is because even when content is removed for the right reasons, it's important to hold onto it for accountability. But automatic removal makes it harder for civil society to do their own preservation because we may never know that that content was ever online. So Witness is working with the Human Rights Center here at UC Berkeley, with Human Rights Watch and Mnemonic in what we call evidence lockers, which is how we can create secure archives that preserve and facilitate access to critical human rights content, even if the public does not see it. From Witness side, we are also exploring how this will be combined with an independent archiving efforts, including the use of decentralized web technologies. Here we see the need for balancing privacy, security, justice, and community ownership. And it's important to remark that archiving is not a neutral act and can support accountability, but also do harm. So how do we center these preservation efforts on the communities and survivors who have been affected by these crimes in a way that is not extractive? There is a range of models and potential ways forward, and there is a great report authored by Professor Koenig and the Human Rights Center at UC Berkeley that looks at 4 models, the legal compulsion model, the voluntary partnership, the independent archives, and the hybrid models. I'm not gonna talk about them because I think Professor Koenig and I could have a long chat about this, but I'm gonna put later on the chat as well a link to the report from the Human Rights Center because it's definitely worth a read if you are interested in mass archiving of digital evidence for international justice. So just to conclude, as I mentioned, the last point I wanted to touch on is when this information gets to the courtroom, what are the challenges for its admissibility? At the ICC in particular, ICC is the International Criminal Court, is becoming a bit of a thorny issue because the procedural framework of the International Criminal Court is very confusing, and it's carried aspects that come from a more inquisitorial tradition, and then during trial parts of the process they are more adversarial. To compound the issue, judges have discretion in deciding when and how the rule of admissibility of evidence, which has translated into two different ways of evaluating evidence, and practice is not very consistent. So you have these two ways, which one is item by item or a fragmented approach, and each piece of evidence is examined in the context of the evidentiary record, and then an opinion is formed to whether the totality of the evidence supports a conclusion. And on the other side, we have a holistic assessment, which some people say that is not suitable for a system where there needs to be proof beyond reasonable doubt, because some evidentiary gaps might be brushed over. And the main issue I see here is that this problem can get compounded with increasing amounts of evidence being generated by digital technologies, is because here I can see the defense not being able to, the accused not being able to defend themselves because they don't know what information is being used to prove what, and what may be sticking in the evidentiary record, so to say. I can put a link to a paper that Lindsay Freeman from the Human Rights Center at UC Berkeley and I co-author, which is actually in the volume that Professor McDermott mentioned. And we look at some of the decisions and analyze how things may play out with digital evidence. And I should say that we draw from previous research conducted by Professor McDermott. So also, if you would like to add some links to your papers, because we've drawn so much from that research. So I think you're going to leave this panel with a lot of resources. So just to wrap it up in a few seconds, moving forward, what I think we need to tackle rather soon is the need of preservation of social media content that may otherwise be lost for future accountability efforts, and scaling up our efforts to authenticate media, so investigators and judges dealing with digital evidence, in particular photo and video, do not suffer from bottlenecks that vast amounts of digital evidence may create when they are inserted into international crimes investigations and trials. I'm going to put the resources now, but I'm going to leave it here. Thank you.
Thanks so much. Thanks for this final, very practical view and perspective. And this opens then our Q&A session. So feel free, everyone who has a question, to put your question in the Q&A chat box. And we already have two very good questions, and part of that already been in a way answered by our last speaker, but probably it will see if anyone else in the panel want to expand more on them. So the first question is how social media providers such as Meta can help with digital evidence, and what are some of the best practices they can adopt. And of course, Raquel, you mentioned that you're already working with Twitter and maybe other companies like on this preservation of this evidence, but I don't know if you want to expand on that, or Professor Koenig or Professor McDermott wanted to say anything on that, on what social media companies could do, what are their side of the stake.
I can jump in a little bit on some of the work that I know, as Raquel had mentioned, Witness, Mnemonic, Human Rights Watch, and the Human Rights Center at Berkeley have been in conversation with the social media companies for quite some time, thinking about how the information circulating on their platforms is potentially helpful to international criminal cases. One of the things that I found most helpful about them is the willingness to engage in a dialogue around what they are actually doing and how they're collecting information, what's being deleted, and their trends towards increasing automation. I think the really eye-opening part for me in the conversations with them is just how many competing considerations come into the calculation around what should stay up and what should come down. And that's only dealing with it as a binary. I think the other components of it has been, how can you deprioritize certain kinds of content so it's not removed entirely, but maybe is less exposed, like people will be less exposed to it if it is upsetting, but maybe not violative of their terms and of use. You know, I think whenever you're talking with the companies around how they might adapt their own practices in ways that support justice and accountability, it really takes a lot of different teams from within the organization. So they have to think about the operational component of it. They have to think about the product development component of it. How can they adjust their algorithms to somehow shift what they are detecting and what they do with it once it's detected? And then it's also a law and policy piece. I think there's a lot of juggling of European legal frameworks, American legal frameworks when they're based in the US, and also just kind of international norms that have been developing around how we want to strike a balance between the privacy considerations, the legal considerations, freedom of expression considerations, and access to information considerations, but also issues of national security. My colleague of mine, Lindsay Freeman, I'm sorry, not Lindsay, but Andrea Lampros and I are writing a book right now called Graphic that is getting into the psychosocial aspects of people being exposed to this kind of graphic content. In the Christchurch context, we of course saw the live streaming of the massacre of approximately 50 people in Christchurch, New Zealand, coming across the Facebook or Meta platform. You know, and I've, you know, heard anecdotally that there have been some serious ramifications from that, and beliefs that perhaps a couple of people actually committed suicide after viewing some of that footage. So there are really serious competing issues that are at stake. I think one issue that we've been grappling with, and they've been kind of helping us think through, is should civil society maybe have an ability to make a preservation request for some of the content that we know might be helpful downstream to these kinds of legal cases? Of course, law and tech are on very different timelines. So it may take 5, 10, 15 years to get these cases built for a particular court system to have jurisdiction over a series of atrocities. How do we make sure that valuable evidence isn't deleted over time, even if not by the companies and their algorithms, by the people who posted it in the first place and suddenly have, for whatever reason, a regret about having posted it? Because once that user takes the content down, the companies themselves are never going to share that information. Right now, the framework is that law enforcement can make that request. A preservation request usually results in 90 days of something being preserved. That is nowhere near sufficient for the international criminal justice community. So there's the timeline piece, there's the who can request preservation piece, there's the who should be able to get access once it's requested and what the frameworks are around that. And then just kind of beginning to establish those norms. We all know the MLAT process of trading information between jurisdictions is incredibly cumbersome and slow in ways that can also be deeply problematic. So that's just flagging a few of the issues. And I appreciate with Meta, they've been willing to engage in some thought experiments and at least conversation about how we might begin to set an international framework for the future that's a little bit more sensitive to the needs of justice communities, considering that they are not a justice mechanism themselves.
Raquel, you want to say anything on that? And also looking at the last question that was posed on, like, with all this in mind, I guess what Professor Koenig has just said, do you think that social media providers are doing enough? That, of course, is a very difficult question to answer. Raquel, you want to?
Yeah. Okay. Yeah. I think Alexa has just given us a master class that has been an excellent overview. In terms of doing enough, I think I would second what Alexa has mentioned, that I can see a true willingness of at least learning from past experience, and we have now the prior experience of a decade of the Syrian conflict with a lot of information being posted on YouTube, and we have seen some policy changes, and like all of us are currently engaging with big tech to help them navigate the complex policy and legal framework, but also from a human rights approach. And I think one of the issues that we see here, and for instance, Twitter recently with Ukraine, they they adopted a new policy on prisoner of war content. So we see that some changes are happening internally at the companies. One of the very sticky points, as Alexa has hinted at, is the international legal framework that is definitely not suited for this type of accountability, but also for evidence that moves across borders and lives in different servers. So the Cloud Act is helping a bit. The current reforms that they want to be that certain countries are spearheading in regards to the mutual legal assistance treaty and the framework is also important. But I think where we are potentially moving towards is these companies providing knowledge and technical resources to potentially independently maintain archives, or to some kind of hybrid model, supranational UN type of entity that will have the mandate to preserve this content. And I think that's where I personally see the value of big tech playing out in this wicked problem of evidence lockers, on like giving the knowledge that they have on how the algorithm is labeling information, but also resources in terms of capacity of servers, and in terms of legal teams that may have evaluated the different competing legal frameworks. For instance, as Alexa has mentioned a bit, is we are talking about mass archiving, and then we have legislation like GDPR. How is this at odds, right? So it is definitely a big challenge, and to me it's one that we should try to find a solution that is not going to be perfect, but we should try to find at least a way forward before a lot of this material is lost for international justice.
Great, thanks. And now we go to another question that goes more into like the procedural, the criminal proceedings and the and some of the things that you all mentioned in your presentation. And the question is how the credibility checks can be done on this digital evidence, and whether it has to be done with digital forensics, and if digital evidence is going to be used by courts. Is there any connection with hearsay evidence as well? And on top of that, so like talking about checking the reliability of this evidence, I want also to ask you from your experience, and Raquel, you mentioned slightly that, like, what is the reaction so far from international adjudicators on the use of this digital evidence? Are they happy to use them? Are they reluctant? So, because of course we know how important it is whether judges and being prosecutors first, but also the judges do feel comfortable in using those digital evidence. So do we see any reaction that? Who wants to answer and go first?
I can take the first question on how the credibility of this kind of evidence can be checked. So the Berkeley Protocol sets out a sort of a three-prong analysis that can be done. So one is looking at the source. Who posted this? You know, have they posted similar content? Is there anything that suggests that this, you know, the source is a reliable source of information? The second is what this asker calls the digital forensics. So looking at things like the metadata. Does this align with where this piece of content was alleged to have been captured and when? And the third is the content analysis. So this could be doing things like geolocation, which is looking at, for example, if there's something landmark in the background, or not necessarily a landmark, but something quite distinctive, can we map that against open satellite imagery to say, yes, it looks like that, you know, I can see this tree and this building and this other tower. This does match with where this piece of content was purported to forensics. The answer is it can be, but it doesn't have to be. And actually often when we look at content that's posted on social media, the metadata is stripped. So a lot of that digital information that digital forensics experts might use might not be available. It can be done with digital forensics, and in the Al Hassan case, you know, one of the expert witnesses is a digital forensics expert. But you know, another person who testified not as an expert witness was someone who'd done a geolocation on a series of photographs to say, I'm pretty confident this is this mausoleum that was alleged to have been destroyed. Is there any connection with hearsay evidence as well? So this is a really interesting question. It's not something I mentioned in the presentation, but around this time last February, I think it was, together with some colleagues from GLAN, the Global Legal Action Network, and Bellingcat, we ran a mock admissibility hearing on open source evidence, because one of the questions me and my colleagues at GLAN get asked a lot is what would happen in England and Wales. We have a lot of cases with more flexible admissibility regimes where this kind of evidence has begun to be introduced. But here in England and Wales and in other systems like ours, we have quite strict rules on admissibility. So to test that out, we put together this mock admissibility hearing with a real life judge, teams of counsel on both prosecution and defense, and some expert witnesses who testified. But this question I thought was really interesting, because I thought this could be hearsay evidence, but both teams of counsel and the judge were in agreement that a piece of content, in this case, a video posted online, was in the nature of direct evidence. And well, the ruling is online if you want to check it out, but they go into why that is. So it's basically a piece of content that so real evidence is defined as the evidence afforded by the production of physical objects for inspection or other examination by the court. So in this case, you present a photograph or a video, it's real evidence, it's direct evidence. On judges and their openness to accepting this kind of evidence, you know, I think sometimes people have this perception that judges are sort of fuddy-duddy, you know, they'd still be writing with a quill if given the choice. But in my experience, that's not the case. They're open to considering it. They're mindful of the challenges. And, you know, again, in that mock admissibility hearing, I was so impressed by the judge who really was asking these really relevant questions to test the reliability of this piece of evidence. So if that's indicative of the broader judiciary, then I think we're in safe hands.
Anyone else who want to? Yeah, sure. Okay.
Yeah, I can add just 3 things on what Yvonne was mentioning on the judges, particularly at the ICC. What we've seen, at least since 2013, is there was a decision on the adjourning of charges by the pre-trial chamber in the case of Gagbo, and we've seen a willingness, or at least a tendency, to limit the scope for open source material. And I'm not talking necessarily about digital or online sources, but as we said, like, there are things here that are not new. And since Gagbo, there's been some tendencies to limit the scope of open source material that is considered admissible on the basis of their reliability. So I just wanted to add that on how generally online sources, open sources have been treated, not necessarily online, but just the idea of other type of sources like NGO reports, for instance, just to connect it to what Yvonne was mentioning on hearsay. And 2 other points I wanted to make on media forensics. What I see interesting here, and something that Witness is working on at the moment, is on what we call detection equity. So who has access to tools that allow you to authenticate information, and how we can spread not only the tools, but also the knowledge to activists that are in these countries where international crimes and human rights abuses are happening. And it's the tools, and it's targeted tools that could be like, as I mentioned, the Eyewitness app, but others that are being created to authenticate information that is already out there online in the wild, but also the knowledge. And this goes back full circle to what Yvonne was mentioning on judges. And yes, they're open to acquire new knowledge, but I also think like there is an important component on having to work with different legal professionals, including prosecution judges, but also documentation teams on the ground to spread knowledge that allows them to be able to verify and authenticate the information they may counter online.
Thanks. Professor Koenig, do you want to add anything on this? Or?
No, I think that was great. Thank you.
Okay, then we go to the last question. I know we've run out of time, but we go to the last question. Very specific on the second protocol to the Budapest Convention. And the question is whether you think will be a game changer or will just be another treaty that goes down in the books?
You know, I can maybe tackle that really quickly. I mean, I think it's often too hard to tell this early on. You know, and it's going to depend on kind of a couple of things. One, law lags tech so dramatically that I think we're always playing catch up in the legal field to figure out how we're going to adapt to very new technological environments that even existed a year before, let alone 20 years before. So I do think there are really acute needs to have written into protocols and to guidelines, just begin to give some kind of consensus and understanding of the way forward as this kind of information may be shared across jurisdictions or territorial boundaries. And it's an evolving set of norms that is really guiding how we think about technology and its use for court processes downstream. I think, though, it's also always going to be incumbent on political will, and political will can shift rapidly depending on the facts on the ground. So I do think right now we're in an environment where we all recognize that digital technologies have made new sources of information available. These sources of information are critical to us understanding the geopolitical realities of how states are targeting each other, how communities are being attacked, et cetera. So we need it. We need these kinds of protocols desperately. The question will be whether they're fit for purpose and whether as people begin to take up the provisions, if they actually do help to solve problems that people are actually grappling with. And I think, again, that's something that time will tell.
If I can add one quick thing on that, the Budapest Convention only applies to cybercrime, but what I would be interested in seeing moving forward is whether some of the language that they have added on sharing digital evidence could be translated or applied to the field of international justice. So that's where I see that pioneering one area that is slightly more mature in this regard can actually benefit the prosecution of international crimes. That was just for like a bit adding on like what Alexa has said, that is like an excellent overview of like how this is going to play moving forward.
Dr. Abrusci, just because the questions have been finished from the audience, we thank the audience for putting forward the questions. One last question from the panel, at least from my part, and it relates to what Professor McDermott Rees mentioned before about the unique evidence and what Professor Koenig mentioned about bias. And my question is about psychological bias. We mentioned cognitive bias. We put forth, the article has been authored about bias in general. And my question is, what about psychological bias in cases that we do not have unique evidence? Meaning, for example, you have an airstrike, and we know that State X perpetrated the airstrike. My question is, video footage of this strike creates also psychological bias to the audience, of course, and maybe also to the members of a fact-finding commission or the judges. And the question is, in these cases, how important is it to rely to digital evidence in order to document the strike to the extent that there is no need to find a particular culprit, physical culprit? So maybe this is the psychological bias is a case of undermining the role of digital evidence in international criminal litigation.
I think we have to be very aware and very careful about how much we rely on digital information to the exclusion of other forms of evidence. I think the gold standard has always been that you want physical, digital, and testimonial information. You're using them to test each other. Ideally, if you are a good investigator, you're using multiple theories of the case or multiple working hypotheses, including those that go against your own gut instinct and your own, therefore, bias. I also think it's very dangerous how, I think Yvonne mentioned this earlier, but how really prominent videos and photographs and narratives around what's taken place and kind of the citizen journalism space can affect what witnesses say. So being aware too that there may be an iterative effect of these videos and photographs on witnesses' memory. We all know that there can be challenges with intake, with how information is stored in the brain and then how it's recalled. And videos and photographs like that can be very biasing in any step along the way of that process. So I think in those cases, you really need the physical boots on the ground information to make sure that ultimately, hopefully, we're not looking to target any one particular perpetrator for a particular set of atrocities, but that actually justice is kept front and center in all that we're trying to achieve.
Sorry, thank you very much. I just realized that I know we ran out of time, but there was another question in the chat, not in the Q&A. So if you do have a couple of minutes to answer this, will be great. So one member of the audience was asking how human rights investigators should verify the authenticity of video's picture if specific technology is not available. For instance, and there is a specific case example here, in the context of Ukraine, there are so many media content on Telegram, and it's so difficult to use them as an evidence. And can you also speak about the overwhelming propaganda as well and its impact to evidence collecting process? So something we already covered, but also moving on to the element of the propaganda and the lack of technology available. Anyone who wants to take this?
I would say this has been partially answered already by Yvonne when she's mentioned the source analysis, the content analysis, and the metadata analysis, because that's the process to verify online information. The advantage of Telegram is that it actually keeps the metadata as opposed to other social media platforms. So that actually helps. And in terms of the propaganda aspect, it can be useful because part of this propaganda as well can speak about the mens rea or the intent of some of the perpetrators. So miss on this information can be actually an important piece of the puzzle in future prosecutions.
Yeah, that's a great point. And I would just add, you know, I think inherent in this question is the assumption that to do some of this verification work, you do need lots of like very high tech solutions. I think, I don't know if my co-panelists would agree with me, but at least at the moment, a lot of this stuff has been done manually. So it doesn't rely on you needing to have like a super duper computer program that you can pop a video or an image into and it will tell you whether it's real or not. And the flip side of that is just how time consuming and resource intensive that is. But yeah, and I think that's an excellent point actually on propaganda and how, I mean, we saw this in several instances, let's say Myanmar, where actual government statements were used as proof of intent. I do think disinformation in general is a challenge to using this kind of information. I think investigators are particularly mindful of the landscape and wary that if they were to rely on a piece of footage that turns out to be falsified or manipulated in some way, then that really could damage their credibility. But kind of picking up on the conversation earlier about deep fakes, the Canadian philosopher Regina Rini has written this excellent thing called Deep Fakes and the Epistemic, I can't remember, but she makes the point that, you know, it's important not to throw the baby out with the bathwater here, that maybe the biggest challenge with deep fakes is not that fake footage will be believed, but rather that real footage will come to be reflexively dismissed as potentially fake. So Witness have been doing great work on this. Prepare, don't panic. My new project, we're going to be looking at this in more detail, the impact of the rise of deepfakes on trust in this kind of evidence, and you know what investigators need to be mindful of when they're collecting and preserving, and when lawyers are presenting it in court, what they need to do. So yeah.
Great, thank you very much. And if there are no more questions from our audience, nor from Dr. Solomon, or nor from our panelists to each other, I thank you very much, everyone and all the audience, for attending this seminar, but mainly to our three speakers for delivering very, very interesting presentation on digital evidence. As said by Dr. Solomon, the recording of this will be available on our YouTube channel, and stay posted for a new event of the International Law Group.
And maybe Dr. Abrusci to add here that our next event already is scheduled on the May 23rd, International Law and Indigenous People. So stay tuned with us, as Dr. Abrusci said, and we look forward to seeing you also there. And thank you very much.
Thank you.
Thank you. Bye.